Thanks. Okay, and I see at least one person in the chat saying that there are people are having a tough time hearing. Can other folks, or is that a general problem, or can you all hear me okay? Okay. Okay, great. And I'll do my best to speak loudly and clearly too. Okay, so so the big picture here is that there are protections against rent money that you owed and couldn't pay from the beginning of COVID in March 2020 through September 30th of this year. But tenants have to do some stuff in order to get protected by those protections. And so, and basically what that means is you have to sign this declaration saying that you were impacted by COVID and either pay some of the rent that you owe or apply for rental assistance before September 30th. And then in addition to the protections for people who can't pay their rent, there are also, and we'll talk about this, what this means in more detail later, but there are just cause eviction protections for everybody. And so if your landlord is just like trying to kick you out for some reason other than not paying your rent, in a lot of cases, you're protected from that right now. So yeah, so that's like the really big picture. And like we just talked about, we can skip to the next slide. Things have been really confusing because there is a series of laws. Instead of just passing one blanket law that would cover tenants who are in trouble all the way through like the foreseeable end of the pandemic, instead what the lawmakers have done is like pass these fairly short-term laws and then at the absolute last minute every time passed another law. So first we had AB 3088, which sort of started these protections that expired at the end of January, and like literally January 28th, the legislature passed SB 91, which was the next extension that expired on June 30th. We had the same deal where like the 11th hour, the most recent incarnation of the law, AB 832, which is what's protecting us all right now. That was passed like right at the end of June. And currently it goes through September 30, 2021. And I don't think that there are currently like possible extensions to that law. People have suggested that this is the end of the road, although also, you know, like we're seeing the Delta variant get pretty serious pretty quickly. So who knows what lies ahead after the end of September. But that's kind of that's how we got to where we are right now. And so what does AB 832 actually do for tenants? Basically, like we talked about, if you had taken the time to learn about SB 91, basically AB 832 kicks the can down the road and extends all of those protections through the end of September. And so, yeah, it extends the timeline to apply for rent relief. It extends it pushes out the earliest date that landlords can start evicting tenants for not being able to pay their rent. And it adds a little bit more detail about like what it will look like when these laws eventually expire. And so kind of like the really high line level stuff is, and this is a carryover directly from SB 91, if you couldn't pay your rent between March 1st of 2020 and August 31st of 2020, as long as you sign this COVID-19 declaration of impact that we'll talk about in more detail later, you're protected from ever being evicted. This is on the next slide, Elliot, sorry. You're protected from ever being evicted from any rent that you owe during that time. So let's say, you know, COVID hit, you got laid off or you missed some of your hours got cut or something and you fell like $1,000 behind on rent, and you weren't able to pay that, even if you still haven't paid it, even if you're not going to be able to pay it by September 30th, as long as you sign the declaration, you're protected from being evicted for it. Okay, next slide. And so then for rent after that, for rent that came due between September 1st of 2020 and September 30th of 2021, as long as you, again, sign that COVID declaration and pay at least 25% of the total rent that you owe during that period by September 30th, you're protected from eviction again. So let's say, you know, you had the $1,000 that you owed from sometime in that period from March to August of last year. And then this year, maybe like you still couldn't find a job, or you, when we went back into the lockdowns in the winter or something, your hours got cut again. As long as you've been able, as long as by September 30th, 2021, you're able to pay at least 25% of the total rent that you owed for this whole, what is that, 13-month period, you can't get evicted. And it doesn't have to be that you are consistently paying at least 25% per month. You could pay it all in a lump sum at the end. If you owe some at the last, if you owe some money in the last month, but in total you paid more than 25%, you're protected. It's pretty generous in that regard. And also it doesn't mean, so again, if you were following the SB 91 stuff, that was originally structured where you had to pay at least 25% of the rent that you owed by June 30th. And this has just kicked that can down the road. So it's not like you had to pay 25% of what you owed from September of last year to the end of June of this year, and then it starts again. It's just treated as one continuous period. And just next slide, please. Just a clarification as to what the law is talking about when they're referring to rent. Rent means, like, you know, the rent for the unit and other charges that are spelled out under the lease, like utilities, but it doesn't include stuff like late fees or like other non-consistent charges that your landlord is like trying to levy on you. So it's pretty clear about, like, they can't just sort of slap extra stuff on there to try and get you in trouble or make it so that you can be evicted. All right, and I think with that, I'll pass it over to Erica to talk a little bit more about exactly about the declaration and the noticing that you have to get as a tenant.
Thanks, Kitty. So right here is just, it's a sample form of the declaration. The landlords are required to give this form to tenants. And so we just wanted folks to see kind of like what the form looks like. If they do not give it to you, can you go back to that slide, Elliot? Elliot, can you go back to the...
I'm sorry, hold on. What happened?
11, yes, slide 11. Thanks.
Can y'all still see it?
Yeah.
Okay, sorry.
Okay. It's okay. So in the red box on the right side of the screen, you can see the link. If your landlord does not give this form to you, or you know that you're not going to be able to pay your rent, you are more than welcome to download this form, and it's in other languages on that link right there where it says housing.ca.gov/tenant/forms.html. Thank you. Can we go to the next slide? So if you're asking, am I able to sign the COVID-19 related declaration financial distress form? So some folks are concerned about, like, do I meet the criteria to be able to say that I can't pay my rent because I have been impacted by COVID-19? So the listed reasons are also on the form as well, but right here you can see loss of income caused by the COVID-19 pandemic, increases in out-of-pocket expenses directly related to performing like essential work during the pandemic. If you have increased expenses directly related to health, childcare responsibilities, increases in costs for childcare, or other circumstances related to pandemic. Next slide. Oh, next slide. So the notice requirements require for 15 days. So all of tenants, all renters who are missing rent payments for the periods from March 1st, 2020 to the present must get a notice about rental assistance before July 3rd, 2021. And even after that, folks are supposed to be getting notices that the rental assistance is available, and you are strongly encouraged to apply for it. So any notice that demands that rent for March 1st, 2020 through June 30th, 2021 must give a 15-day notice and attach a declaration of financial distress. So you should be getting like 2 different forms. And if you want to know how do you go about turning in the declaration to the landlord? So you have 15 days to submit it, and that is not including Saturdays or Sundays or other holidays. If you look at the notice, it's on either the back page or the second page of the declaration form. It'll tell you how you can deliver it, but always make sure that you do it in a way you can prove you turned it in. So just take a video or a picture and keep a copy or picture of it. And also, if you're paying like with money orders or we always suggest that you do it by certified mail, which is only, I think, it's less than $5. I know if you take it and get it mailed certified, but keep your receipts. Next slide. So this is just more information about the 15-day notice requirement. So if you return the declaration, then all of the COVID rental debt is going to be converted into civil debt. So 25% of all rental debt will come due, like Kitty was mentioning about, on September 30th, 2021. The collection cases cannot be filed until November 1st, 2021. So there's a 1-month gap after eviction protections expire on October 1st, 2021. What if you miss the 15-day deadline? Turn it in anyway. Even if the landlord says it's late, turn it in. You may still complete a declaration within the time frame of filing your answer, which is a 5-day period, if your landlord takes action to evict you. The court will hold a hearing to determine if the tenant had a good reason for not submitting the declaration on time. That is really important to remember. Next slide. So when we're talking about fighting a 15-day non-payment eviction notice, so just because the notice is invalid, if it is missing one of these steps, doesn't mean that a tenant might end up losing their house because it's hard to get a lawyer, and judges sometimes overlook or differentially interpret protections. You want to push for the strongest protection, but be strategic and document anything and everything. If there's probably 2 things that we're going to really want people to take away from here. And it's 1, apply for rental assistance, no matter what. Apply for it, even if you think maybe I make too much money or I don't have everything they're asking for. Apply for it anyways. And document anything and everything. In documentation, some folks get confused maybe about well, how do I document this? You could take a piece of notebook paper, and as long as you're writing down the what, who, what, when, where, and why, like on this date, this person, this happened, that is good enough to protect you. So I would say don't think too much about like, how do you document it? You could do it as simple as just taking a notebook paper and start writing down information. Next slide. This is a nice picture. Rent striking is not new. This has been going on for years, especially during the Great Recession. So we're going to talk about rent collection. So landlords can bring the civil cases to recover the rent beginning November 1st, 2021. An award to landlords must be reduced by any amounts or financial assistance received by the landlord. So this is also why it's really important that folks apply for rental assistance, because even if you might be eligible to the rental assistance, the court is going to take that into consideration when looking at reducing the amount that they're trying to take you to court for. Next slide. Very important, again, I'll say apply for rental assistance. You should apply for rental assistance or update your application if you have already applied. If you have already applied, follow back and reach out to the program that you've applied for to get an update. So the bill also included new rental debt protections. This Assembly Bill 832 includes that landlords can't use an alleged COVID-19 rental debt as a negative factor to evaluate rental application or refuse to rent because of the COVID-19 rental debt. So some folks might think that these judgments, these rental debt judgments are going to be used in the same manner that maybe an eviction might be used when folks are putting in rental applications and looking to rent. These are going to be sealed from public record indefinitely, actually. So they cannot be used as a negative factor when trying to evaluate you for being a good renter or not. And it cannot ever be sold or assigned to creditors if the tenant with the debt would have qualified for certain rental assistance funding. And there's new late fee protections. Landlords cannot charge or attempt to collect late fees for COVID-19 rental debt when the tenant returns the COVID-19 declaration form. Landlords also can't increase fees charged or charge services previously provided without charge when tenant has provided COVID-19 declaration. So if you've turned in a COVID-19 declaration form and maybe your lease expires and they want to renew it with you, and you notice that, hey, they're charging me for, gosh, it could be anywhere from like, maybe you didn't pay for water, maybe you didn't pay for sewage before, and they're adding that onto your thing. If you've already turned the COVID-19 declaration form, they cannot do that. They cannot increase fees that were already provided to you without charge. So that's always a key when you're looking at new charges. Were these services provided to me beforehand and I didn't have to pay for them? Next slide. So protections against lockouts and retaliation. By the way, this is criminal for a landlord to lock you out, to change your locks without going through the process by the courts. Your landlord cannot lock you out or retaliate against you for asserting your rights. If this is happening to you, you should contact us and an attorney as soon as possible. So 100% of rental assistance. I think, is this where you come in, Elliot? Cool. So Elliot's going to take over.
I think this is it. Thanks, Erica. I just want to pause real quickly to see if anybody had some preliminary questions on the things that you've heard so far. And also, I want to remind folks that if you want to be followed up with after this meeting, send us your email address. You can drop it in the chat. You can DM one of us that information. And that way we can get this slideshow to you as well as some other information and such after this meeting. So please, if you haven't done that, do so now. But yeah, I just want to take a moment to see if anyone's got any questions at the moment.
And also, I'll just say that a couple of us are willing to stay on after the meeting to answer questions.
Yeah, good point, Erica. I don't think we mentioned that before, but we are going to hang out afterwards. So if you have something that you want to ask about that you don't want recorded, for example, we'll have time after this to discuss with you, and hopefully we can answer some more questions then. Okay, well, hearing none, we'll soldier on. So this next section is about rental assistance. You've probably heard a lot about it in the news recently with the federal CDC eviction moratorium expiring and people screaming about the hypocrisy. Like, how can you end the eviction protections without having given people rental assistance, right? It seems insane. Well, here in Sacramento, the Sacramento Housing and Redevelopment Agency is the agency tasked with getting all of this rental assistance money out to tenants and or landlords. So, like Erica was saying, if your landlord has been harassing you or calling you or emailing you or knocking on your door saying, "Where's my money? Where's my money? Where's my money?" First of all, that's harassment. But second of all, you don't have to engage with that. You can engage with this program that will get them their stinking money and hopefully get them off your back. And it's a crucial protection for people who may have been impacted by COVID-19. So what do you need to do? You need to go to www.shra.org/SERA, or you can go to the housing.ca.gov website, and they actually have a portal there where you can click on it. You can type into the portal where you live, and it will direct you to the local agency or state agency that is tasked with getting you that money. So if you were impacted by COVID over the last year and you were unable to pay all or a portion of your rent and you're concerned about being evicted because of that, apply now, like now. So it used to be that the rental assistance offered was this weird 80-20 deal. They've actually increased that now. So now you are eligible for 100% of the money that your landlord says is owed over the 18-month period between March 2020 and September 2021. So I don't want to hear landlords complaining anymore about, "Oh, poor me, I don't have any money anymore." They can get 100% of it back through this program. It also used to be contingent on the landlord agreeing to this. Now that's not the case. So your landlord can apply for this money themselves, or you can apply for this money and have it sent to your landlord. If your landlord refuses the money, it can be sent directly to you, and then you can cut your landlord a check. So now there's 3 ways to get payment, and that is a way to get around this loophole where some landlords, just to be spiteful, were saying, "I don't even want your money. I just want to be able to evict you." Well, now they're going to get their money one way or another. And if they refuse your payment, document that. Document everything. If you try to cut them a check for the rent and they say, "No, I don't want it," document that, because if it comes to a court proceeding later on, that will be crucial information to show I tried to pay, they didn't want my money.
Yeah, another thing I'll add real quick too, Elliot, is it's really important too that you at least communicate to the landlord, where you can print, by email. I think text is okay too, but authentication is always a big deal in courts, proving like that the person is who the person is behind the email or whatever, or the text message. But let them know that you applied for rental assistance. That's really important too, that you communicate to your landlord that you applied for rental assistance.
Yeah, that's a great point, Erica. A lot of tenants have a very acrimonious relationship with their landlord, and a lot of us believe like the less I have to talk to this landlord, the better my life is. But in this case, secrecy is not the way to go. You want to be upfront in writing, telling them, "You've been asking me for this money. I have now applied for it. You will be contacted by SHRA soon, and they'll verify some things, and they're going to get you your money. Be very upfront, and again, get it in writing. Another thing that was addressed recently is that tenants who moved out of a unit but still owe on that unit can now get money, can now get the rent on that old unit paid back, even though they're not there anymore. So there was a big criticism with the first round of rental assistance where folks said, well, this is BS. Like, my landlord hounded me and forced me out of my home. Now I'm gone, and now you're offering all this money. Well, with this new round of assistance, you can actually pay your old landlord and get them off your back. So even if you don't live in the unit anymore, you should still apply. And finally, it says tenants applying for or granted assistance must provide the funds to their landlord within 15 days, or possibly face late fees or other penalties. So like I was saying before, there are now 3 ways to get your landlord paid. One of those ways is that the SHRA or whatever agency will cut you, the tenant, a check directly. Do not go and cash that check. That check must go to your landlord, and it must go within 15 days. And if you have penalties written into your lease for late fees, they can then begin assessing late fees if they don't get that money within 15 days. So very, very critical there. Now, some folks have already applied for the emergency rental assistance program, and they're in limbo, and they're thinking, what do? I put in the application, I haven't heard much, I don't know what's going on. If you've already applied, you don't need to start a new application. What you need to do is follow up on your previous application. It could be that they're waiting for additional information. It could be that you need to update a portion. It could be that you need to verify some information on there. It could be any number of things, but don't just let it sit there. Be vigilant, check back on it, and don't let it fall through the cracks. Don't assume that the SHRA is going to do all the work, because 1, they're overloaded, and 2, they're human like the rest of us. So these automatic payments for rent debt assistance are going to go into effect over the coming weeks. Again, tenants must, if they cut you a check directly, you must return that money to your landlord within 15 days. Landlords who apply directly will get the money directly, so you'll never actually see it. And so we recommend, again, follow up with SHRA or whatever the agency is that's providing this money. Do not let this be a mystery, and don't let your landlord get that money and never tell you about it. And conversely, don't let the SHRA just drag you along and along and along. You need to hold them accountable. This is the public's money, and it's meant to help tenants, and that's exactly what it should do. So stay on top of this stuff.
And if anyone does have problems getting a hold of them, and you've gone all the routes that Elliot is outlining right now, don't hesitate to reach out to us.
Yeah, sometimes it takes a little extra kick in the pants to get them engaged. Okay, and then finally there is, so say you apply for this money, and for whatever reason SHRA or some other agency says, I'm sorry, you don't apply. But you know in your heart of hearts, yes, I do. I qualify for this money and I need it. Well, they have an appeals process set up. So once you get a notice saying you are not eligible for this money, you have 30 days to appeal that decision. You can do so using the Housing is Key website there. They have some instructions there for you. So basically what they'll do is they'll reopen your application, they'll re-scrutinize it again. You'll get a case manager or a staff person assigned to you who will then work through all of your application to verify all of it and allow you to make revisions if, say, it could have been as simple as a typo, right? If it says ask for your income and you put an extra 0 on there, Of course, you're not going to get the money, but you should have an opportunity to correct that mistake. And then you'll basically reapply, they will reassess the application, and hopefully you will be approved for the funding after the appeal. And with that, we're on to the next section, just cause. I think it's back to Erica.
Thanks, Elliot. So we're going to talk about just cause protections. There were just cause protections that got extended for all renters, not just renters who live in certain protected housing types. So there were protections extended till September 30th, 2021. So there was a bill that passed, I believe, in 2019. It was called AB832, Assembly Bill 1482, and it included just cause protections. So a tenant cannot be evicted with a no cause notice before October 1st, 2021. And AB 1482 just cause protections require that a landlord have a reason to terminate a tenancy, and not all types of housing was covered before, but the COVID tenant protections extended this protection to tenants in all types of housing other than student dormitories. So just cause is extended to all tenants, yes, no matter length of tenancy or type of housing, and again, other than student dormitories. And what that means like student dormitories that are on college campuses. And evictions for substantial renovations or remodel can only be given in order to comply with major habitability issues. So that typically means that code enforcement is involved. Tenants can be evicted if a court case or an eviction notice predates March 2020. Or a landlord provided the tenant with documentation of available rental assistance, and the tenant still fails to pay 25% of the rent due between September 20th, 20 to September 30th, 2021. So just to kind of review what at fault just cause reasons to evict are, and there, it's really important that you remember that we're going to go over there's a difference between at fault and no fault. So an at fault reason would be that the tenant fails to pay rent that's not being impacted by COVID-19. If they have a substantial lease violation, commits a nuisance, and again, a nuisance because, and I'll just say this because we have seen cases come across us recently that landlords are trying to get people out. And this is also retaliatory, but kind of hard to prove, but by saying that the tenant is being a nuisance. And there is a legal definition of nuisance and a high bar to set that standard. And so if you know someone or you yourself are receiving this treatment by a landlord and they're saying this, feel free to reach out to us. Another one would be for damages. So if someone damages the property significantly, if they engage in criminal activity, if they sublet without the landlord's permission, refuse to let the landlord enter the unit to make repairs, and fail to vacate after terminated as an employee, or if they fail to vacate after providing written notice of their intent to vacate the property. Next. So a no fault just cause reason to evict would be if the landlord intends to move themselves or their family into the unit, and there has to be documentation of that. If they want to withdraw the unit off the rental market, if they wish to demolish or substantially remodel the unit, so it can't be minor repairs, it has to actually be unsafe and unlivable. And if the owner is complying with a government issued notice to vacate the property. And that would mean that relocation assistance, they have to offer relocation assistance for that.
And I'll just mention those top three right now are rampant. The and they're rampant as like exploited loopholes. So uh, landlords will tell you that they're going to move into your place and you have to leave, but they provide no evidence of their intent to do this. Or one that's really common right now because the real estate market is like molten lava hot is landlords will claim I'm selling the place. I'm going to sell it, so you have to leave. But they don't provide you with the contact for a real estate agent. They don't show you an escrow account. They don't show you a contract of sale. It's nothing except their word, right? And we've had experience with one complex in Midtown where the landlord said they have to demolish the place. The place is unsafe to live in. We have to demolish it right now. You have to be out. So everyone left after negotiating like a severance with the landlord. So they all got some free rent and a little bit more on top, and they all left. Well, lo and behold, almost a year later, or maybe more than a year later, the place is still there. So this big rush to get everybody out of there was a bunch of BS. So that caveat with documentation is very critical. Don't let your landlord bluff you into homelessness. They're going to say all kinds of stuff to get you out. We've even heard of landlords posting like those signs, you know, like the realtor signs. They'll post one of those in your front yard to make you think the place is about to get sold, just as like a tactic. So don't fall for it. Do not leave without proper documentation and push back.
Yeah, and I'll just say too, thanks Elliot for actually bringing up those examples. Elliot was really critical in helping the folks in Midtown do that negotiation, and so that's one of the great things that the tenants union has been able to do is help when tenants come together. It's pretty powerful, and they were able to help leverage that and get those negotiations happening with the landlord. And myself personally have been dealing with my landlord selling the property, and because she didn't do it properly, I stayed past the date that she was in the notice and have been forcing the new owner to do it properly. So now I've bought myself another 4 months. So knowing your rights is really important, and the tenants union has been really key in helping win some successes for tenants. So the landlord no-fault eviction relocation. No-fault evictions require that a landlord compensate tenant for relocation by paying tenant an amount equal to 1 month's rent within 15 days of serving the eviction, or waiving last month of tenant's rent. Now, there's a caveat to this, and the caveat to this is that this has to be with the tenant's permission. So they can't, because we've seen a notice before where they send the notice and tell the tenant, we're going to waive your last month's of rent to cover the relocation assistance. That has to be with the tenant's permission. So if that does not work for you, then make sure that you can communicate that to them, or reach out to us and we can help you communicate that with the landlord. If the landlord fails to comply with the relocation requirements, the eviction, sorry, I have my dog. The eviction is considered null, so it's invalid. Next slide. Is this the eviction process?
Yeah, I think that's me.
Yeah.
Yeah, so we talked about the protections if you couldn't pay your rent. We talked about the additional protections, the like just protections for everyone if your landlord wants to get you out of your place for some other reason. But what we haven't really talked about, it's like we've been throwing around the word eviction a lot. Like, what does it really mean? What does eviction really mean? And like, what does it really look like to get evicted? And so The first step of the process is really the thing that we've mostly been talking about, which is the notice. And so that's, you know, what we were just talking about with the no fault evictions, that's going to be a 30 or 60 or 120 day notice, depending on the specific circumstances. And those are if you've lived somewhere less than a year. Under ordinary circumstances where you aren't protected by these just cause eviction protections that Erica just walked us through, your landlord can give you a 30-day notice to vacate, and that means get out in 30 days or I'll start the eviction process. If you've lived there for longer than 30 days, then you're entitled to 60 days notice that you need to vacate. And if you live in the city of Sacramento, which sneaky, if you aren't sure if you live in the city or not, look it up, because lots of things that seem urban and like they're part of the city are actually unincorporated Sacramento County. So if you live within the real city limits, then you're entitled to a 120-day notice, because there are some, the city passed its own like local protections. So you get a notice like that. If, on the other hand, you're at fault, like we've been talking about, up until September 30th, if you owe your landlord rent, they can give you a 15-day pay or quit notice, which means pay the rent or sign the COVID-19 declaration within 15 days, or they can start the eviction process. Under ordinary times, that would be a 3-day pay or quit notice. And then similarly, if you're violating a lease or doing something illegal, they can give you a 3-day cure or quit notice, which means like cure the violation, you know, whatever, like get rid of the pet that you have that's against the lease, or like stop selling drugs or something, or move out, right? So the first step is you get this notice. And if you respond to the notice, then that stops the eviction process, right? So if you pay the rent that you owe, or if you move out within the 60 days that you're allocated, then in like the legal sense of the word, you haven't been evicted, right? You don't have an unlawful detainer, which is like the legalese term for an eviction, on your record. If like a future landlord looks you up, they're not going to see that you've been evicted, even though of course you had to move out of your house not on your own terms. Like that's messed up and problematic, but it isn't an eviction in the legal term. And that's a big deal, right? Because landlords can and do discriminate against you if they look you up and you have prior evictions on your record. If you don't respond to the notice appropriately within the time frame of the notice, that's when the landlord can go ahead and start the actual eviction lawsuit. And so that means they go to the court and they say, hey, I gave my tenant a notice and they didn't respond to it. Can you send them a summons? And so then you get this thing called a summons and complaint from the court. And that's the start of the actual unlawful detainer lawsuit. And so if you get that summons, you have 5 days to respond. It's called filing an answer, or you lose by default. And if you lose by default, that means you don't even have to go to the court. Your landlord can say, hey, it's been 6 days. Did my tenant respond? If they didn't, then they can just ask the judge to rule against you without ever hearing your case, which is really undesirable. So if you get a summons and complaint, make sure you file an answer. Even if you're not really sure what to do, anything is better than nothing. If you file the answer, then your eviction suit goes to court, right? And you go in front of a judge and you have to argue your case, or try and find a lawyer to argue your case, which is really hard to do as a tenant. But at that point, it's up to the judge to decide who's right, you or the landlord, and make a ruling. And unfortunately, usually eviction court is stacked really heavily in favor of landlords. If you've ever been to small claims court, nobody gets a lawyer in small claims court. That's not how it works in eviction court. You can get lawyers. Guess what? Most of the time your landlord has a lawyer and you don't, because it's expensive, and it's also hard to find people that do landlord tenant law, especially around here. But sometimes if you have a really strong case, you can win. And you can also do things like ask for a jury trial, which at worst delays the actual court date because it takes a while to find a jury, and at best like maybe gives you a better chance of winning, stuff like that. But so only if you fail to respond to the answer or lose in court do you actually wind up with an unlawful detainer, which, remember, is like the weird legalese word for an eviction. That's the point where you wind up with an unlawful detainer on your record. And like Erica talked about earlier, I think there are some cases where if you got one of those unlawful detainer evictions for not being able to pay your rent during COVID, even though it's on your record, it's sealed, so a landlord can't search that one and like see that you had an eviction. But in general, then it goes on your record. And then in addition to that, once you either lose by default or lose in court, then your landlord can go back to the judge and ask the judge to order the sheriff to carry out a physical eviction. And so at that point, the sheriff will come to your house, they'll leave a notice on your door. Usually they give you 5 days warning. So they say like, we have been told to evict you, we'll be back in 5 days. And they don't always show up like right on the 5th day. Sometimes it's a little bit longer than that, but that's kind of the general time frame. And the sheriff's department is they're the only people with the power to legally carry out a physical eviction. So they can come like put your stuff on the curb and change the locks on the house and like physically move you out. Nobody else can. Like Erica mentioned earlier, your landlord definitely can't do that. And so that's like the whole arc of the eviction process. And I think it's important to think about that because it's pretty frightening to get one of those initial eviction notices on your door, whether it's a 30-day notice or a 3-day pay or quit notice or whatever. Like a lot of people think, shoot, I have 3 days to pack up all my stuff and move if I can't pay the rent or whatever. And as you can see, looking at this, it's actually a way longer process than that to really like have the rubber hit the road and be forced out of your home. And so that's important to remember. If you get a notice, think about what you're going to do right away, but you don't necessarily have to panic and think like, I have 3 days, let me start packing. Like there are lots of opportunities to intervene in the process and fight it a little bit. And if you move to the next, actually 2 slides, Elliot, we'll talk a little bit more about the eviction notice procedure when things revert back to normal, quote unquote, on October 1st. And so, like I was just saying, there's a lot of opportunities to intervene in the eviction process. And one thing is to make sure that the process was actually carried out properly by your landlord. So for starters, eviction notices, those original like 3/30/60-day notices, those need to be served either in person, so your landlord or the representative has to find you and like personally hand you the notice, or they have to be what's called nailed and mailed, and that means mailed to you, obviously, and then posted on your door. And so an email isn't a valid notice, a text isn't a valid notice. Your landlord can't call you and say, hey, I need you to move out. Can you be up by the end of the month? None of those are legally considered a notice, right? And then, like we talked about, the self-help evictions and lockouts by your landlord, that's always criminal. There's never a time when the landlord can change the locks. And then as far as the notices, I guess I jumped ahead of myself and talked about this earlier, but so if you're at fault, usually that's going to be a 3-day notice, either 3 days to pay or quit, or 3 days to fix the violation of the lease, or right now until September 30th, 15 days to pay or quit or sign the COVID declaration. And those days don't count Saturdays, Sundays, and like bank holidays, so stuff like Christmas and the 4th of July. And then, like we talked about, there's the no fault notices. So you get 30 days if you've lived there for less than a year, 60 days if you've lived there for more than a year. And then you get 90 days if you are a Section 8 tenant, or if if you're getting the notice after the house has been foreclosed upon. So if your landlord couldn't pay their mortgage and the bank takes over the house, oftentimes they want to kick out tenants and they have to give you 90 days. And there's a couple of other things, like if for notices to pay your rent, it's got to say how much you owe. It's got to tell you where to pay it. It always has to include the names of all the adults that live there that they want to evict. And so, it can't just be like to the residence of blah 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 address. It's gotta kind of spell it out. And so, yeah. Okay, great. And let's jump to the next one. So. Like we've been talking about, kind of like how are you going to fight these notices? Sometimes there's these like procedural things, right? You can be like, you didn't do this thing right. And then what you can force the landlord to do with that is say, you know, like let's say that you get a 60-day notice to vacate, and you're protected by just cause, and the landlord didn't specify why they want you to vacate. You can go to them on like day 40 or day 50 and say, hey, you actually didn't serve this notice properly. And they can't just amend the notice and be like, okay, here you go, move out in 10 days. That resets the clock. So they'd have to give you a new 60-day notice and push the timeline up, kind of like Erica talked about that she was able to do with her landlord in her situation. Then obviously for a cure or quit notice, you can cure the violation. And if you do that, you want to demonstrate it. So let's say, you know, we're increasingly seeing landlords do really petty things, like maybe your lease has a revision that says you can't have like potted plants on the balcony, that, and no one has cared about that for the 5 years you've lived here until suddenly people want to be able to evict you, and so they give you notice for that. Well, get rid of the plants, sad face, and then take photos, right? And like text your landlord or email your landlord as soon as possible and say, hey, I got your notice, the plants are gone. Here's like the time-stamped proof that I did what I was supposed to do.
Yeah, Kitty, can I piggyback off of that real quick too?
Sure.
Yeah, because I was just helping a tenant who got a 3-day pay or quit, and they were saying, or not pay or quit, it's a 3-day quit notice. And so most of the times that you get a to quit notice, if it's something that's correctionable or curable, then they need to give you the benefit of the doubt and allow you time to correct it. So like Kitty's saying, the plants, or maybe you put a camera outside your house or something like that, that's a correctable lease violation according to them. So they can't force you out for that. And one of the things that tenants often forget to do, or just we don't think about that's important, is to document how you're correcting it. So through text message, through email, just make sure that you respond and say that, you know, you said on this date that I did this and you need me to correct it. And so this is how I'm complying with it. So that's a great point. I think Kitty, you touched on that.
Yeah. And same thing too, like, so, or along similar lines, if you're dealing with some type of pay or quit notice, you also want to document that as much as possible. Like, you know, hopefully you're paying with something like a check or money order, so you have a paper trail of the payment, or you're paying with an online system that provides like verification of what you're what you're paying. And then in addition to that, the other sneaky thing that we're seeing landlords do with pay or quit stuff is, remember how we talked about way at the beginning, like rent that you owed back in April of 2020, even if you owe the whole month's rent, you can never be evicted for that rent as long as you sign that declaration. What we're seeing landlords try and do is sneaky stuff. Like, let's say you pay this month's rent and they're like, oh, well, how do I know it's for this month? Like, I'm going to consider that payment for rent that was due, like, you know, 12 months ago in April 2020 or whatever. And so when you're making payments in like the line on a check or money order where you specify what the payment is for, you want to unambiguously state what you're paying. So like if you're not able to pay your full rent right now and you pay like 50% of your August rent, state on the line like 50% of August 2021 rent for blah blah blah, you know, like your address and stuff, so that if the landlord tries to get you on that stuff and say like, oh no, they still owe me all of the rent for August, you can say no, like I paid you for that, right? So yeah, basically the moral of this entire training is document everything as much as possible and push to get stuff in writing. But so those are some options to push back on some of those notices. And then with the no fault notices, like we talked about, landlords are really doing a lot of shady stuff to try and get around the just cause protections that mean that they can't just kick you out for any reason right now. And then they also sometimes they do stuff like not pay rent relocation. So just looking for all of those things and kind of checking, like, did they check all of the boxes? That can be a way to, if not overturn the eviction, at least like fight it and slow it down and give yourself more time to do things on your terms. And then the last thing to remember about the non-payment notices is if you didn't get that required notice about your ability to apply for rental assistance, it's not considered a valid notice. So if your landlord gives you a 15-day pay or quit notice, and it's just like pay the rent or else. And it doesn't include the information, that required information about where you can go to apply for assistance. You could go back to them and say, hey, this notice is invalid. You didn't give me the information you have to give me. And that resets the clock again. So they have to give you like a new 15-day pay or quit notice, right? Okay. So I think we can go to the next slide. And then the last part of the, well, about evictions in general, that it's sort of like heightened during COVID, is that landlords can't do what are called retaliatory evictions. And so it's always the case that if you assert your rights as a tenant by, say, like asking for your landlord to do repairs, they can't, that within 180 days of that, so like 6 months, if you like call your landlord and pester them to like fix your heat or something, and then they try and evict you within 6 months, it's the case precedent is that it's presumed that that's a retaliatory eviction, and they're saying in their head like, oh, this is a problem tenant that wants me to provide the things that I promised that I would provide to her. Let me just kick her out. And so there's precedent for tenants winning their cases in situations like that by saying this is retaliatory. I was just trying to assert my rights, and now I'm being kicked out. And then there are additional like fines and protections if you took advantage of the protections during COVID of not being able to pay your rent, and then the landlord tries to kick you out after that. There's even more protections, and there's like a bunch of language about how they can be fined for trying to kick tenants out who took advantage of those COVID protections. So that's another thing to think about is, and sometimes even it may not even be related, but it may help you out. Like if you happen to have put in a repair request and then the landlord is trying to kick you out for something that isn't for a not at fault reason that isn't seemingly related to your request for repairs, like maybe you can use that anyway. Okay, next slide. And then just to recap, if you can't find a way to fight like the notice on its face, just to recap the unlawful detainer stuff. So if the notice expires and you weren't able to like either fight it or comply with it, and you get that summons and complaint, if you're named in it, you have 5 days to respond. So if it shows up and it says your name, if it just shows up and it says the address, unlike the notices, you still need to respond to that, but you have a little bit more time. You have 10 days. And like we talked about, if you don't respond, you lose by default. The sheriff actually doesn't necessarily arrive within 2 weeks, but that's kind of about the earliest that they could show up. Your landlord still have to actually go back to the court and ask for the court to order that sheriff's lockout. So sometimes we see it where like people don't respond, but the landlord hasn't gone back and asked the court to rule in their favor. In that case, you can file the response later than 5 days, but 5 days is like the time you have where you're protected, where the landlord can't go in there and ask for you to lose by default. And then like we talked about, it's really helpful to get the advice of legal aid, some type of legal aid, to file these answers, although you can do them like yourself as just private citizen if you really have to. But groups like Legal Services of Northern California can help you file an answer, and that's one of the things that they kind of focus on, is like making sure people file the right like motion to quash and motion to demur. There's all these different motions, but like we talked about, filing anything is better than filing nothing. Okay, and then a few more kind of like random tidbits that have come out of AB 832. So one of the things that they have required that they've required the Judicial Council, which is like it's like the state level organization that does legal stuff. They've required them to make standardized forms. So it used to be stuff was like a little bit different in Yolo County compared to Sacramento County. And the idea is just to make it easier especially for tenants, this state level body is going to create standardized forms that can be used for the COVID non-payment stuff until 2025. So that's hopefully going to make it like easier, because now like if somebody in LA figures out this stuff and does a training, it would apply to all of us here in Northern California too. And then like we mentioned earlier, if you lose an eviction court, for a eviction suit that was related to your inability to pay rent during COVID-19, that's masked forever from the public record. So usually those things are just masked for 60 days to give you a little bit of time to move. But if you have a eviction on your record because you couldn't pay rent during COVID, a landlord will never be able to like search that and find it. And then, yeah, and like from October of this year to March of 2022, if your landlord files an unlawful detainer for COVID rent debt and they can't prove that they tried to get the rental assistance, you can do that. You can file a motion to quash, which is one of the ways to respond to the unlawful detainer summons, and basically say, throw this case out. This guy didn't prove that they tried to get rental assistance. So those are just a couple of couple extra things basically to fight the eviction. And I think that wraps up this section, and I'll hand it back over to Elliot. Unless there are questions. That was a bunch of information in a short period.
Questions, anyone, before we get to the very last section here?
And you can type them in the chat, or feel free to also just like unmute yourself and speak your question if that's easier.
Okay. But feel free to drop a question in the chat anytime. So we've talked all night long about these new tenant protections. And while I think we should be excited into a certain degree about these, they're neither adequate nor are they permanent. You notice all of this stuff, they all have expiration dates. So the rent debt program works from what, March 2020 till next month, or the end of September. These noticing requirements that used to be 15 days will soon go back to 3 days. The Judicial Council has to make these new standardized forms, but they only have to do it until 2025. The idea being, I guess, that tenants need protection, but only for a few months, I guess. And then after that, we're all going to go back to normal and life is going to be all hunky-dory again. Well, we know that that's not the case. And so we want you to be aware of some things that these laws do not do, and then talk about what we can do to overcome the deficits that are, our legal system and our politicians, who are all bought off by landlords anyway, what we can do to overcome those deficits. So one thing I want to run through quickly, I'm no math expert, I'm no professor of mathematics here, but a lot of folks get notices for rental increase and they shrug and they go, well, I guess my rent's going up again. Well, in the city of Sacramento, and actually statewide, there are laws that dictate how much your landlord can raise your rent right now. For this year, that amount is 9%. They are allowed to raise it a maximum of 9% if you live in a unit that qualifies for this rent cap. Not all units do, of course. If you have questions about whether your unit is covered by this, you can contact us and we'll work through that together. Also, Tenants Together, another statewide organization, they have a really good flow chart on their website that walks you through these sorts of things. But get in touch if you're unsure if you're covered by this or not. But anyway, how much is 9%? So the equation is your old rent minus your new rent. Take that number, divide it by your old rent, then take the decimal place and move it over 2 spots, and you get the percentage that your rent has changed. We know that we don't have to worry about it being a negative number because we know our rent never goes down. It only goes up year after year. But for example, if you were paying $1,000 on your last lease and your landlord comes and says, hey, sign this new rental agreement. Oh, by the way, your rent is going up to $1,400. Well, it used to be you had to take that on the chin. and now you do have at least some small protection. So $1,000 minus $1,400 is negative 400. We take the absolute value of that, or the positive number. We divide that by the original rent, which is $1,000, and we get 0.4. Now 0.4, we move the decimal place 2 places over, and we find out that's a 40% rent increase. That's a lot, and not only is it a lot, but it's illegal. And in the city of Sacramento, there are processes you can use to contest that, and statewide there are ways you can contest that as well. If you are given an illegal rent increase of more than 9% and you are interested in fighting back, get in touch with us. Next, what are some other things that we don't see in these tenant protections? Well, we have a quote unquote tenant protection program here in Sacramento that was basically designed to run interference for landlords and real estate speculators. It has not been very helpful to tenants so far, and I don't see it improving, frankly. We also have this whole idea of like, oh, they're going to forgive some of the money for a while. Like if I owed rent before, they can't evict me for it now, but eventually that money is going to come due. This does not cancel rent. This does not cancel your quote debt, or what your landlord considers a debt. So many tenants will still be on the hook for a lot of cash even after this is all over with. Also, there are loopholes galore in the just cause protections. We were talking about some of those earlier. Landlords will pretend that they're going to move in. They'll pretend that they're selling the apartment complex. They'll pretend that, oh, suddenly I need to make big renovations. Like, I'd love for you to stay, but I need to renovate this place. Meanwhile, there's no evidence or proof that any of this is going to happen. But if they intimidate you or trick you, you may end up leaving when you shouldn't leave. There's also nothing that regulates the existence of slumlords, who are rampant in Sacramento and throughout the state. So they are still in business, probably doing better than ever. There's no anti-harassment protections. So over this last year, tenants all over have been getting hounded by their landlords every single day. Where's my money? Where's my money? Where's my money? Where's my money? And there's really not a lot of legal protection against that sort of behavior. And finally, as we were talking about earlier with court proceedings, landlords almost always have an attorney, or they may be an attorney themselves. And when they take you to court on an eviction proceeding, 8 out of 10 times, the tenant does not have their own attorney, and they're totally mismatched in the court, and the landlord ends up prevailing. The new laws do nothing to address that inequity. So here's where I get to do my rallying cry at the end. Alone, we are isolated, we can feel powerless, and we can feel totally at odds with our reality. You know, we feel that it's coming at us from all sides. But what we don't realize is that our neighbors, our community, our allies, we're all going through this together as well. So again, there's a great quote. I don't know, somebody said this many, many years ago, but we use it all the time now. If I owe my landlord $1,000, that's my problem, right? But if me and my fellow tenants all owe our landlord $100,000, that's a big problem for your landlord. And that's why they're pushing to get all this free rent debt crap from the government, because they're in a hole right now and they want you individually to have to figure this stuff out. But that's not the way it should be. A strong tenant union movement could turn 19 million potential evictions into 19 million union households across the United States. Organizing moves us from crisis to uprising. And that's a crucial, crucial point. So finally, what can we do? Well, we don't have time tonight to start the revolution, but there are a few things you can do materially, like actionably, to start this process and make your life and the life of your neighbors a lot better. So as we've done tonight, you arm yourself with your rights. That's your baseline, though. That's not the ceiling, that's the floor. That's the floor on which you can stand and then fight for even more. Your landlord takes a small risk messing with just you, but they take a big risk messing with a group of tenants who are organized, who know one another, who know their rights, but also who know what they want and are willing to work and sacrifice to get it. So realize you are not alone. Talk with your neighbors and honestly and openly share your experiences with them. It's one of the greatest tactics of all time for isolating and atomizing tenants is to make you believe that you are the problem. Everyone else around here, they're all fine, right? I don't have any problems in this place except for you. Well, that's a bunch of BS. And they're telling that same story to 20 different people. And they've got us looking at each other like we're the problem. The problem is at the top. So landlords, they own the courts, they own the property, they own the politicians, but they don't own you. Collective action is the way forward. So assert your rights, apply for the rent debt, know when they can and cannot evict you. But more than that, you can ask for a lot more and you can win a lot more. But we have to do it together. And finally, that leads me to our contact information, because what we'd like to do is work with you on a movement of organized and agitated and inspired tenants all across Sacramento to talk with one another, to meet up, to find out what it is we need, what it is we want, and think about a plan on getting there. And we can't do that alone, so we want to bring you with us. So you can get in touch with us at our website. You can find us on social media. You can email us. You can call us, or you can fill out our intake form, tinyurl.com/STU-COVID. Fill that out, and one of our organizers will get back to you, and we can hopefully talk about how we turn tenancy and our individual struggle into a collective win for working class people. And with that, I'll shut up.
Yeah, and we're going to stay on here for folks who have like individual